represent the appellants in this matter. This is standard foreclosure, residential foreclosure that was brought by U.S. Bank. Issues in this one are going to primarily focus on the admissibility of the evidence that were admitted over objection, that being the default letter and also a mailing log to show proof of mailing. This is going to be a paragraph 22 issue that we're raising this appeal on. This matter was brought forward and the evidence provided evidence was submitted by the plaintiff with the testimony of their witness, Ms. Tolan. They first introduced exhibit number 4 at the trial, which was the default letter, showing that it was a certified letter. They went through the typical business predicate. It was objected to based on the trustworthiness or the reliability of the actual evidence. The trial court overruled the objection, stating that the issues presented primarily went to the weight of the evidence and did not provide the appellants with the ability to move forward and show the unreliability, the trustworthiness of the document prior to admitting that. The same was done with exhibit number 14, which was the collection log or the letter log that was admitted over evidence or over objection. And again, the objection was raised and prior to having the ability to really show the unreliability of that evidence, it was admitted into evidence again due to the trial court saying that it went to weight and could be directed on cross-examination. We take issue with the fact that exhibit number 4 and number 14, the letter log, were the only evidence to attempt to show proof of mailing in this matter.
That's not entirely accurate, is it? There was also testimony identifying her background and her knowledge of the mailing procedures. So it's not just the documentary evidence themselves, is it?
Well, it isn't. The evidence was all, the testimony was also presented talking about her knowledge, but that's where we take issue with it. When we went through the cross-examination and the trial court's orders regarding that testimony, it was presented based on the fact that this witness, this trial witness, had personal knowledge of the routine business practices of one, Waltz, the third-party mailer, just given a general sense of that she went to the facility, saw how it was done, but really didn't provide anything more.
Did she really say general sense? Because Mr. Waltz, who owned that company, invited her and personally trained her according to her testimony. So she seems to have a little more specific knowledge than the cases that you cited wherein we reversed for insufficient proof because the person never worked there, or they didn't visit, or they didn't have the requisite knowledge. But this person actually was personally trained by the owner of the third-party vendor company and had access to their system to make sure that it was mailed.
Well, that's what she testified to. However,
we can't rule on credibility here. We can't reweigh the evidence.
And so, we understand that. The issue being to is the interplay between Waltz and Caliber, the servicer of this loan that she was testifying to, that she had the routine business practices of Caliber and how that interplayed with Waltz. The testimony that she provided was that she was in the default department, that she went through all these checklists of what was done, what was performed based on her personal knowledge being in that department. It later turned out that she was never in that department, never worked in any department other than being a traveling witness.
The test isn't whether she worked in the department, the test is whether she was trained. Isn't that correct?
Well, she said she was trained in Waltz.
So does that become basically a credibility issue? I mean, you started out your presentation talking about the lack of reliability. Isn't that essentially a credibility determination by the trial court based on all her testimony, including the cross-examination, as to the basis of her knowledge and the foundation that she presented.
I believe it gets to the admissibility of the business record she's attempting to provide through Caliber's routine business practices and business records, and showing the interplay that she has knowledge of the ability.
I understand what you're arguing, but tell me what is lacking from her testimony.
It would be knowledge of Caliber's business practices of mailing and how they obtain information from Waltz to place it in their system, so that that documentation can be presented and so the.
So it sounds like, I mean, it sounds to me what your argument is, at its heart, a challenge to the business record exception to the hearsay rule. Is that what you're challenging?
Correct.
Okay, I just want to make sure I understood that. Do you have any case law that supports the idea that, based on the nature of this particular testimony, that the trial court committed legal error in finding her testimony to be sufficient?
I believe this is close to Mace, M&T, second DCA case, where that individual also testified regarding the servicer's business records and the ability to show the routine business practices of the servicer, and also the third-party mailer in that situation.
And had the witness in those cases that you referred to, had the witnesses testified as to the training they had regarding the actual mailing procedures used for the case?
Not direct. They did not state.
Thank you. That's what I wanted to know. Thank you. You can go on. I'm not trying to cut you off. You satisfied my question.
Okay. And when it comes to the Exhibit 14, which we also challenged in this one, again, we're going to the legal sufficiency of that evidence and the admissibility of providing the letter log into evidence to show proof of mailing. It was their only attempt to show that it was mailed through a physical document. We objected to it. The objection was originally sustained. Court wanted more from her. And that's when we got into the situation where she started testifying as to her position in the default department, how Caliber is able to collect that data from Waltz, how it's shown in the Caliber system. However, it was shown that it was, one, unreliable, and two, she didn't have personal knowledge of the actual business records or the routine practices in obtaining that information. In that, originally she testified that her knowledge and how it's inputted into the system, which was supported in the trial court's order on this matter, was that she's one of only 6 people allegedly that has access to this Waltz system that's able to track mailing, and that ability to track and view this information is then inputted into the system, which is all contained in the letter log. However, that was shown to be incorrect in that the information that was inputted into the letter log was allegedly done by someone in the default department, which is different than the department she's in, different than the work that she does. And there was no testimony as to actually how that interplay between Waltz and this default department inputs that information into the collection log. It was simply put that it was different than hers. And we objected to it based on the hearsay within hearsay and the reliability issues and her failure to prove any kind of knowledge as to how that input was actually presented from Waltz to the default department, which would provide an admissible record to show proof of mailing. And based on the fact that these items were admitted over objection, had they been properly, the objection sustained, there would have been no other evidence shown that the letter was mailed. And then we would reserve time for further rebuttal.
Hey, Mr. Diaz, you're up. Thank you. Good morning, Your Honors. May it please the court, Adam Diaz on behalf of the appellee. The crux of this case is the admissibility of the documents and whether or not the testimony was sufficient under the business records exception. That is all the court can view at this point in time. The brief, however, and the argument does seem to focus on the credibility of the witness and what was stated, which the court cannot reweigh the evidence. Based on the testimony before the court from Ms. Tillman, the court should affirm the judgment and find that the court did not abuse its discretion in entering exhibit number 4, which is the demand letter, and exhibit number 14, which is the collection notes. So first we'll touch on exhibit number 4, which is the demand letter. In this case, Your Honors, there was a demand letter entered into evidence as exhibit number 4. It's dated December 29th, 2016. And the testimony in this case regarding the demand letter strictly follows the business records exception. This court was affirmed by the Supreme Court in Jackson versus Household Finance Corporation, which I believe the underlying opinion was written by Your Honor, Mr. Sylvan. And in this situation, the Supreme Court affirmed the second DCA, finding that stating the business record exception verbatim is sufficient to get the document into evidence, unless there's something else in there to show that the document is not reliable. And in this case, the evidence was very clear that the demand letter, which is generated by Caliber, it is housed in their system, it's made at or near the time of the event, was met to enter the document into evidence. The objection in this case that was put into evidence is not even clear that it was actually a hearsay objection. Counsel for the appellants in the trial court stated that they wanted to object to a reliability of it, but did not specifically state at any point in time regarding the demand letter that the demand letter itself was hearsay. So the court correctly overruled the reliability objection and allowed the appellant's counsel to cross-examine on that issue to weigh the evidence. At no point in time during the admission of the demand letter did the appellant request to voir dire the witness or do any more questioning regarding the hearsay, any hearsay objection. So respectfully, the demand letter was properly admitted under the rule of Jackson versus Household Finance, and there was no issue with the court admitting that into evidence. So let
me ask you this question, because we've got several decisions reversing based on insufficient proof because the person doesn't have the requisite knowledge nor experience. So what distinguishes Ms. Tillman from those other cases that gives her the requisite knowledge, experience? I mean, you just can't parrot the factors of 98036. That's unacceptable. So
understood. So did Your Honor finish the question?
Yeah, I'm finished. Go ahead, sir.
So the majority of this case goes to what her training and knowledge was for creating the demand letter and sending the demand letter. In this case, Your Honor, there is a lot of citations to the record, and I can give you some of those citations where Ms. Tillman talked in depth about her training, specifically on page of the record 2529. This is page 2079 of the actual transcript. She talks about the process of how the demand letters are created and how they're mailed out and how information is put in her letter log from Walls. On page 2662 of the record, she talks about how she was trained on the creation. She worked in the department as a single point of contact at one point, and she was trained by Walls about how the tracking is put into their system and how the demand letter is created. On the record 2660, page 82, lines 7 through 8, she was personally trained by Mr. Walls. I've read a lot of case law on demand letters being sent. This court has issued a lot of opinions on that. And this is the first case that I've read the facts of the case where the actual individual testifying was trained by the owner of the company, Mr. Walls, on how their process is for sending the demand letters, putting the information in their system and transmitting it. Again, she also reviewed that she had personal knowledge by reviewing the business records that the letters were created and sent. That's on page of the record 2662, page 93. How the letters are specifically created and generated and sent, she also testified on page 2539 of the record, 2540 of the record, and 2541 of the record. On cross-examination, Your Honor, there was questions specifically by appellant on Was the demand letter created and sent? On page 2666 of the record, she clarifies that she is one of the 6 individuals with access to the wall system. She viewed the demand letter in the system of Caliber and confirmed that it was sent. Again, on 2667 to 78, she testified again based on her personal knowledge of reviewing the records that it was sent via certified mail. The demand letter that was admitted into evidence, Your Honor, specifically states on it, sent via certified mail. She specifically stated that the letter was sent certified mail and first class and was actually undeliverable via certified mail because there was a refusal to sign the letter. And again, this is page 2678, page 112 of the record, she had more testimony regarding how the tracking number comes into the system from Walls. And on page 115 of the transcript, she specifically stated again, based on the cross-examination, that she reviewed that the letter was sent. So this case is distinguishable from the other cases that have been entered by the courts. I'll just say that the Knight case is a case, the Mace case, where there was actual testimony throughout the record over and over and over again on her training. The Mace case is very factually distinguishable from the case before this court. The reason in the Mace case, the third-party vendor in that case was characterized as a law firm. It was McCullough Raymer that prepared and sent the letter. The witness did not have any testimony about the policies and procedures or any training she had with McCullough Raymer on how the law firm sends out their record. So because there was a complete lack of evidence regarding that type of third-party vendor, the court properly held that there was not enough proof of mailing. In this case, Your Honor, this case, there was no third-party vendor that was a law firm. It was an actual vendor that Caliber had access to their system. Their systems communicated with each other, and the number, like the tracking number from the wall system, would go into the tracking number for Caliber. This case is more akin to the case of Bank of America versus Engel, which is another case that Judge Silberman was on the panel for. In that case, the facts of this case are very, very, very similar. In that case, NationStar was the servicer and used the Walls third-party vendor as well. I think based on the case law that's been just out of the second DCA alone, Walls is well known in this industry as a third-party vendor who sends demand letters. There's a lot of opinions on Walls. So in this case, the NationStar rep testified, once the letter gets imaged over to Walls, Walls of course prints it out, mails it. They give NationStar confirmation that the letter was sent. Like I said earlier, this was the collection notice. This is showing that the demand letter was sent by Walls. The tracking system that Walls has is the US Postal Service. So basically they take that information and they put it in our system and we can track the letter. That is verbatim what happened in this case, in the testimony in this case, essentially between the connection of Caliber and Walls. And in US Bank versus Engel, the court found that due to the knowledge that the NationStar witness had regarding the training and the regular routine practice, there was sufficient evidence to show the demand letter was sent. The other case that I'll say is distinguishable, that was a recent opinion out of the second, was Roche, R-O-E-S-C-H, versus US Bank National Association. This involves a different servicer. This is a Wells Fargo servicer, where in that case, similar to the Knight case, the witness had no independent knowledge of the third-party vendor's mailing practices, had no testimony that they were trained in the practices, and could not opine any opinion or any testimony on how the mailing is done from the third-party system at all. They relied on the demand letter itself in that case, essentially saying because there's a barcode on the demand letter, it was sent. And the court correctly found that that was insufficient because there was no testimony regarding the training. In this case, based on everything that I've articulated to the court throughout the record, it's apparent in this case that this witness had unique knowledge. It's important that the court didn't just rule after the trial on this one and move on. The court took everything under advisement and actually entered an order in this case, which the court can find on 2598 of the record, where the court actually took its time to review the record again to determine whether or not there was sufficient evidence of proof of mailing based on the regular business practice. And the court wrote a few-page opinion finding that this case also follows another case, which is Deutsche Bank versus Harris. That's a 2019 case out of the Fourth DCA with very similar facts to this court's case in Angle, where the third party testified similar in this case. There's a third party vendor trained in the systems talk to each other, and the witness in that case also had access to the system. And the court found under that case as well that the testimony was correct. So really, this case is akin to many other cases where servicers are using the Walls system for sending demand letters. So what is the appellant really asking this court to do? The appellant's really asking this court to weigh the credibility because there was an interrogatory that apparently was not a complete statement on how demand letters were sent, and said that Caliber sent the demand letter, which is also true. The witness testified that Caliber also sends demand letters. And the court is not here to reweigh the credibility of the witness. I think if you review the transcript as a whole and look at the questioning done on the direct and cross-examination, it's clear that the appellant had unique knowledge because she was trained by Mr. Walls herself on how the systems work. The witness testified she had many years in servicing. She's worked for Caliber since 2016, prior to the date of the demand letter being sent. So respectfully, Your Honors, I believe the court correctly admitted both of the documents into evidence. I think this court should follow the cases of Angle and Harris. This case is distinguishable from the only case that the appellant really seems to be relying on, which is Mace, and the judgment should be affirmed.
Okay, Mr. Eisenman, give you about 5 minutes for rebuttal.
Thank you. Just brief rebuttal. Again, this isn't necessarily a credibility issue that we're asking this court to review. This is an issue regarding the admissibility over objection of the two items that went in there to show proof of mailing. And again, they pointed on it that she had unique knowledge talking about the Waltz system and how she was trained. However, when it gets to the Caliber and how that interplay works with Waltz and the receiving of that information, it's lacking. This witness was lacking the knowledge and the ability to testify as to the business records or how the routine business practice of Caliber was done. She was the one that signed the interrogatories that were admitted into evidence, in which case, was specifically asked, how was the demand letter sent? And she said it was sent by Caliber, and it was done by regular mail. Nowhere was Waltz mentioned, nowhere was certified mail mentioned prior to her providing testimony. And then she also goes into this unique knowledge of the Caliber's business practices. It's cited in the court's orders, and it went into in-depth. And during trial, the plaintiff's counsel specifically referenced to her ability and her knowledge, having worked in that department and her specialized knowledge in that department. However, that wasn't the case. She was providing testimony based on her experience. It must have been in another servicer, and how another servicer might have contained these records and produced these documents, working in the single point of contact, because on cross-examination, it was shown that she had never worked in the default department and had only worked as a traveling witness and no other roles at Caliber since 2016. That conclusively shows that she did not have the requisite knowledge that she testified to regarding the business practices of Caliber, or how Caliber takes the information from Walt to put that into their system. She was unable to testify to how that input gets into Exhibit 14, other than saying there's some kind of interplay between the default department and Waltz, without going on to explain any further after her testimony was challenged regarding her actually working in the default department, which the court specifically relied upon to render its judgment and to also admit the records into evidence. Based on this lack of knowledge and the inadmissibility of Exhibit 14 and Exhibit 4, removing those items and removing the testimony that shows that she lacked the requisite knowledge, then there was no sufficient evidence to show proof of mailing. And based on that, we would ask that the court reverse the decision of the trial court.
Okay, thank you both very much. In order to leave our virtual courtroom, recall that you need to click the leave button in the lower, I think, right-hand corner of your